Thank you all again for joining us today. We're lucky to have Gil Hopenstand and Anne Manalili from the U.S. Small Business Administration here to speak with us regarding EIDLs, PPPs, and other other SBA loans, both inside and outside of bankruptcy. I just have a little bit of housekeeping before I turn it over to Gil and Anne. If you would all please make sure that your name, not your telephone number or anything else, is on your Zoom sign-in. That is for CLE credit purposes. If you are, never mind, excuse me. The CLE session is being recorded for future viewing, as you may have already heard. So in light of this, we do ask that you please keep your microphones muted during the presentation. You're welcome to type any questions that you may have during this presentation into the chat box. We're going to do our best to monitor that chat box, and we may interject your questions during the presentation. But regardless, we will have an open Q&A session after the presentation concludes. The materials for today's session are posted to the ACBC website as always. They've also been placed here in the chat box on Zoom. We'll put them there again in just a moment. If you have just joined, you might not see them yet. If you don't see the PDF pop into the chat box within the next 5 minutes or so, you may not be able to see PDFs there. Let us know so we can make sure we get those materials to you, and also importantly, that CLE certificate, because we will be placing the CLE certificate for today in the Zoom chat box. That is the only place you're going to see that CLE certificate, and we will make a verbal announcement that you need to grab that certificate when it's posted. But again, if you can't see the PDFs in the chat, please let us know by either typing your email into the chat box and we'll grab it from there, or you can always send us an email to admin@acbcforum.org, and then we can email the certificate to you. With that, I will turn it over to Gil and Anne with a great big thank you for presenting to this big group today.
Hi, and good afternoon. My name is Gil Hopenstand. I'm a district counsel at SBA. I've been with the agency since 2015. And prior to that, I was a bankruptcy attorney in Los Angeles. So I'm one of those rare, weird people that actually finds bankruptcy interesting. I've recognized several of the names on here through some cases that we've worked on, and I'm happy to present today. I'll toss it over to Anne, my colleague Anne, for her to introduce herself, and then we'll get the slides going.
Hi, everyone. I'm Anne Manalili. I am kind of recent to the SBA. I joined in 2022, so I come from a perspective where I didn't really know anything about it either. But prior to that, I was a commercial litigator and bankruptcy attorney. So I've represented a lot of creditors and kind of been in similar positions as you all were. So.
Great. So hopefully you can all see the screen now, and we will just sort of jump in. Great. So I'll start off just very big picture with statistics that 99% of US businesses are defined as small. SBA has its own definitions of what are small that I'll get to, but most of what you see are small businesses. And that small businesses employ 47.1% of the workforce of the United States. But also true is about 2 out of 3 businesses fail by the 10th year. And as that's just sort of the reality of the economy. And that's somewhat of what we want to talk about today, is what happens when there is some sort of financial distress. So I'm gonna start by talking about a little bit about SBA loan products, and there are different kinds. So I'll get into some more detail, but big picture again, there's what's called the 7A loans. That's comes from Section 7A of the Small Business Act. Those are loans that are made by a lending partner. They are made, it could be a big bank like a Bank of America or Wells Fargo. It could be made by a credit union. Later we had some other fintechs and whatnot, but the money is made by a third-party lender. The loan goes out to the borrower, and SBA is a guarantor on the backside for that loan to the lending partner. And as it says in the picture here, SBA sort of reduces the risk and enables easier access to capital by being a backstop for the lender. The lender is then more able to make small business loans, is willing to take the risk, is willing to extend credit that might not be done otherwise. So those are the 7A loans. 504 loans, they are long-term fixed rate financing. Again, we work with lending partners and what are called CDCs, and they are sort of these middlemen brokers, which we would then step in and take over the loans. But in that sense, the lending partner, meaning a big bank, a credit union, whoever it is in first position. SBA goes in second position. And these are mainly to purchase real estate or big ticket equipment that you can then pay out over 10, 20, or 25 years. So SBA is rare in that we would give you a 10 or 20-year loan on equipment. And then there's disaster loans, and those are now upticking based on the storms that hit the southeast. But in the normal world, we have what's called physical disaster loans, and those are loans to repair and replace physical damage. But then there's also the reality of there's what's called an economic injury. So if there is a flood or a fire and people move out of your town, even if your restaurant is not physically damaged by the fire or flood, you now have lost customers. People have moved out of town temporarily, seeking shelter, whatever it is. They're not, fewer people are going to be coming to shop at your store or eat at your restaurant, and you may suffer economically. So it's a reality of that you may suffer something that isn't hasn't damaged your brick and mortar, but you nonetheless suffer a loss. So these are just sort of big picture, the types of loans that SBA does. Oops. Okay, so a 7A, and I won't go into all the little details here, but it's generally up to $5 million. It's SBA's flagship program. These are processed in SBA's offices in Citrus Heights, California, the suburb of Sacramento, where they have the Loan Guarantee Processing Center. Certain lenders can also qualify and apply for it to be what's called PLP, Preferred Lending Partners, where they then can make a lot of these processing decisions. So they have what is called delegated authority. So the banks themselves can actually paper the loans and do everything, and they just will then notify SBA, hey, we've made a loan to this party at this amount, and it sort of bypasses our processing center. And then the guarantees, as certain loans can be paid down over time, you can apply for another one, because that cap of 5 million generally applies to all the guarantees out there. In the 504 world, bear with me, there we go. CDCs, these certified development companies, they're nonprofits that SBA regulates. They're the ones that sort of make these marriages between the borrowers and the banks, and they come in as second lien position. So the lender would be first, the CDC would be second, and then SBA comes in and buys out the CDC position. So we come in with sort of that mezzanine financing, and we take the second lien position. So if you were to see an SBA loan in which SBA is second on real estate, it's probably this type of product. I won't go into lots of the details of eligibility, but there are, you have to be eligible in order to receive an SBA loan. It has to be what's called small, and small can be based on your number of employees, depending on your category of where you work. It all goes by the NAICS code, the NAICS code. And depending on what sort of business you are, it'll go based on your revenue, your employees. It has to be a for-profit company. It has to be in the United States. The owners have to pass certain background checks. So you have to be eligible. And then there's also ineligibilities. So things that are, we don't lend to just what is called speculation or passive. You can't use an SBA loan to buy an apartment building and then just sit back and collect rent. The idea is to hire employees to stimulate the economy. You can't do things that are illegal under federal law, and that sometimes gets a little squishy where it is legal under state law but illegal under federal law. And to that, I'm sort of referring to a lot of the cannabis and hemp and CBD things. So SBA has various rules regarding that. And then we also look at, for eligibility, we look at what's called affiliation. So we look at common ownership and common management with other businesses. And if we deem you to be affiliated, then we could rope all other businesses in, and that might tip you over the limit to be what's other than small. Let me talk just for a moment about the guarantee process, and I won't go into a lot of the details here, but in general, as I mentioned, for a 7A loan, the SBA guarantees the repayment to the bank. I'll just whatever bank, credit union, again, third-party lender you use for the example, SBA guarantees their repayment. So the relationship is not between SBA and the borrower. The relationship is between SBA and the lender. And so each lender will then have a form on file, Form 750, and it's an agreement. It's signed by the bank and it's signed by SBA. We acknowledge our SBA's responsibility to honor the guarantee, and the lender promises to do certain things. And if everybody does what they're supposed to do, then we would honor the guarantee. So the way it would work is that depending on the loan product, SBA might guarantee 75% of the loss. We might guarantee 85% of the loss. We might guarantee 50-50. It depends on the loan products and the loan amount. Anne is going to be talking about some of our sort of COVID products, which included the PPP loans, and there the guarantee was 100%. So hypothetically, if the bank ends up suffering a loss of $100,000, they would then tender it to SBA saying, SBA, please honor the guarantee. It's what we would call a charge off. And then that $100,000 that loss would then be split. So if SBA takes on 75% in that hypothetical loan, we would then pay the bank $75,000. Bank would only suffer a loss on its books of 25. And that percentage also goes for liquidation costs. So sometimes the bank has to hire counsel or chase them or to do something. We would then participate in that same percentage wise. So when will SBA accept a demand? Usually the borrower there has to be a default of more than 60 days. And then the lender has to liquidate it as if it were any other Bank of America loan, for just hypothetically. They can't sit on their hands, or they can't do any less effort to try and collect repayment or chase it down just because SBA is guaranteeing it. There might be an incentive there to just sort of sit back, but they have to do everything that they need to do. And once they have finished their collections efforts, then they turn it over to SBA. So they would turn in a form, a purchase demand kit. They would turn in their request for SBA to honor its guarantee. There would be a screening. Sometimes it'll go through a legal review, a financial review. Sometimes there's a second legal review. On here towards the bottom, it talks about a repair or denial. So a denial is we are denying the guarantee request. And so it could be, to go all the way through and for SBA to honor the guarantee, the lender has to originate the loan correctly, close the loan correctly, service the loan correctly, liquidate it. And what I mean by correctly is according to SBA's SOPs, our standard operating procedures. So the lender has to follow all our rules. And if the lender follows all our rules and nonetheless suffers a loss, we will then step in. Sometimes the lender does something wrong. Either it could be in the origination and made a loan that it shouldn't have, or it did something along the way that comes up in that legal review, financial review. We can either issue a denial and we say, sorry, because of you didn't follow certain rules, we are not going to pay you back, or what's called a repair. A repair might say, because you did or didn't do something in particular, there was an additional loss of $1,000, $10,000, whatever X amount. Therefore, we're dinging you that X amount, and then after that, we then split the difference, or however otherwise. So a repair is just sort of a particular financial hit at a certain dollar amount, and a denial is we're not paying you back because you didn't follow our SOPs. So that's the normal SBA loan products, the 7A, the 504, and the disaster loans. Anne will now take over and talk a little bit about what happened during COVID, but I will just sort of preface it by saying that we'll talk about the PPP loans. You don't see a lot of PPP loans left out there because so many of them were already forgiven, and then the rest that are forgiven, they've been either paid back or stuff. So there's just a lot fewer of them left in circulation.
Yeah, so I feel like these are the hot button topic loans or the hot items. Paycheck Protection Program, PPP loans, that started in April of 2020, and it went through May of 2021. SBA issued about 11.8 million loans, totaling almost $800 billion. And as Gail said, a lot of them have already been either partially or fully forgiven. So what we have been normally dealing with lately or currently are the COVID economic injury disaster loans, COVID EIDLs. SBA made 3.75 million loans, totaling about $377 billion. SBA stopped processing these loans in May of 2022. If you could skip to the next slide, Gil. One of the questions we get a lot are, understanding what the COVID EIDL loan program was about, what were the parameters. A lot of borrowers don't retain or lost their loan documents. If you do, you can always request that from the SBA. But in general, the program allowed for a maximum loan amount of $2 million, and what the business qualified for depended on largely what their reported gross revenues were, which is what was listed in their application. Again, some of the applications, they're self-certifying, so whatever the borrower listed is what the SBA went by. It's a loan term of 30 years, payable at fixed interest rates of either 3.75% for private businesses or 2.75% for nonprofits. Some people have confused. So there was a total deferment period of 30 months. However, interest did continue to accrue on those loans during that deferment period. Some people mistakenly believed it was an interest-free period, but it was actually just a payment-free period. So the loan continued to accrue interest, although borrowers weren't required to repay it until 30 months after the initial loan date. I know people have also received modifications, but the deferment period starts from when the loan was first issued. Another question we often get is, was the loan secured? And that depended on the loan amount. So basically for anything under $25,000 and under, SBA did not take a security interest. But for loans of $25,001 and up, the SBA took a security interest in the borrower's business assets, basically all of the assets. And so a borrower was asked to execute a security agreement, and a UCC-1 financing statement was filed. The amount of the loan also determined whether or not it was personally guaranteed. I'm sorry, just stepping back a little bit. SBA also took an interest in real property owned by the applicant business, and those were for loans over $500,000. You don't see that very often. There's not a lot of businesses that also own real property, but in cases where they are, SBA did take the best available mortgage on that. In addition to, with respect to the security interest for the UCC-1 filings, SBA charged a one-time fee of $100, which was taken out of the proceeds. And again, the amount of the loan determined whether or not a personal guarantee was required. For loans greater than $200,000 for for-profit businesses, a guarantee was required. And depending on the type of business, would determine who was required to guarantee that loan. And so you see over here, it lists categories of who is required to guarantee the loan. For nonprofit businesses, a guarantee was not required. Gail, if you could skip to the next slide, please. So included in the next two slides actually are just a brief breakdown of the types of loans that we've discussed: the PPP loans, the COVID EIDL loans, and then on the next slide will be the disaster loans. It's a good reference point, but I did want people to pay particular attention to the category for use of proceeds, especially when it came to Paycheck Protection Program loans and COVID EIDL loans. This is where people can kind of get in trouble if they weren't using it for what it was issued for. So for PPP loans, those were for payroll expenses, including payroll costs, employee benefits payments, mortgage interest, rent, and utilities, basically things that the business needed. The COVID EIDL loans were for working capital and normal operating expenses. Basically, if the business needed to purchase inventory, equipment, could also be used for payroll. Debt payments for business loans was also an allowable expense. But there, were instances where the borrower used it for purchasing real estate, purchasing expensive cars, purchasing, boats, things like that, or investing it in investment accounts, purchasing stocks or playing the stock market. Those were not appropriate use of the proceeds. Gail, can you turn to the next slide? Sorry, the 14, slide 14. Okay. There were also, I want to say, grants or funds that were advanced to borrowers that weren't necessarily loans and do not need to be repaid. That includes, they're kind of loan adjacent, but it includes COVID EIDL advances. When a borrower applied, they can check the category asking for a COVID EIDL advance. It could be anywhere from, I want to say, $1,000 to a maximum of $15,000, and that would be issued to the borrower for their use. That did not have to be repaid. It's not taken out of the total amount of the proceeds of the COVID EIDL that was awarded. So, for instance, you get a $50,000 COVID EIDL loan, and you were given a $5,000 advance. That $5,000 is not part of the $50,000. There's were loans, grants for restaurants, bars, and other food service businesses that had to shut down. It's called the Restaurant Revitalization Fund. That does not need to be repaid. And there were also for shuttered venue, there's a shuttered venues grant for live venue operators, promoters, theatrical producers, performing arts organizations. All of those received grants to help them get through COVID. Next slide, please. Okay, so to help deal and handle the $3.75 million in loans that were issued on a rather short basis, SBA created a servicing center called the COVID EIDL Servicing Center, or CESC for short. That was designed specifically to service all of these loans. There are currently over 1,650 managers and staff dedicated to servicing these loans and providing customer service to borrowers. It sounds like a lot of employees, but they are very inundated these days. So I know there have been some complaints from certain borrowers, but you just have some patience as they are dealing with a lot of different requests. And the types of transactions that they handle include subordinations, when SBA is asked to subordinate its lien position so the borrower can get a different loan. Assumption agreements, where a business is agreeing to assume the borrower's loan, releases of collateral, substitutions of collateral, re-amortization, refund requests, for overpayments, verification of mortgages. Next slide, please. And then there's the hardship accommodations, which we'll talk about a little bit more about in a later slide. Payoff requests and changes of ownership and sale of business or assets. I should add that in relation to this, there are also offers in compromise, which aren't as super common, but they have been requested. They're generally not really processed if the debtor's plan is to stay in business, but are just often related to the sale of or proposed sale of the business or assets. And all of these actions that require changing the loan terms, changing the obligors or ownership, changing the business structure, selling collateral, all of that requires SBA's prior approval. A lot of borrowers, when they face financial distress, they'll start to dissolve the business. They'll try to find buyers, new investors or owners, or sell off collateral, or selling the business itself without notifying SBA. And they can find themselves in a bit of trouble, when SBA does find out about that, or when they file bankruptcy, especially if there is a personal guarantee involved. I had a case where the borrower sold the business, but because they didn't notify SBA, they are still on the hook for everything because they are the contact person. They signed a personal guarantee. So always reach out to CESC before taking any action. And all of these types of requests start by contacting CESC and often usually require an application. And the CESC will send an application and it'll list out documents that they'll need to process that request. There are a few ways that you can contact CESC. You can call the toll-free number, which is listed in the slide, or send an email to the COVID EIDL servicing@sba.gov, or you can contact SBA via direct message through the My SBA Loan Portal. Next slide, please. So the My SBA Loan Portal is, I want to say it was developed either the later part of 2022 or 2023. And basically it's a web-based platform which allows borrowers to access, view, and manage all of their SBA loans, meaning all of the COVID EIDLs, the disaster loans, the 504 and 7A loans. So basically all of the loans in one dashboard. And it's kind of a one-stop shop. It allows them not only to view the loan, but also to make payments, either one-time payments or recurring payments or cancel payments. It allows borrowers to access statements, including tax forms. And there's also a way to contact SBA directly through that portal. Next slide, please. One of the things you can view is the status of the loan and to determine if there's any delinquency. If you see, sometimes a loan can be placed in an incorrect status, or depending on if a bankruptcy was filed, you might not see certain payments being applied. So that you can contact CESC and try to find out why, but you'll be able to see that through the portal. And I just wanted to point out that there is a little button that looks like an envelope, and it says send a message. It's just kind of hard to see on the slide, but if you can enlarge that, that's the button that you could press to send a direct message to SBA. It's highly recommended that your client register and use the portal to make payments. There's a little bit of a push to have borrowers do that rather than sending mail-in checks, which could get mailed to the wrong address, could get misdirected, either because it's not the mailing address isn't labeled correctly, or there could be problems with mail delivery, or sometimes if the loan number isn't on there or it's ineligible, it could cause a delay in properly applying the payment, especially if the borrower has multiple loans and it's unclear which loan it should apply to. But paying it through the portal is faster, and you could see the application. It's usually within a day or two. It's also important to keep the information current, whether it's via the portal or contacting SBA. Only authorized people that's listed in SBA's contact will be able to speak with a SBA representative. So oftentimes companies will have their CFO or attorney or someone else try to contact SBA requesting documents or information, and SBA representative can't talk to them if they're not listed as an authorized contact person. So it's important to keep that information up to date. Next. Oh, sorry. One other thing is you can choose whether to get electronic or mailed statements. So that could be very helpful for in case you need to file bankruptcy or do some other reporting. Next slide, please. Okay, So one of the remedies SBA has developed to help borrowers who are having problems making payments is to establish the hardship accommodation program. And again, this was started because borrowers started once the deferment period was over, some borrowers had problems making their monthly payment. Basically, this program offers a reduced monthly payment for a period of 6 months. The portal also has information on this hardship accommodation program, but it's also on the regular SBA website. For borrowers with loans less than 200,000, they can actually apply directly on the portal with a self-service button. But otherwise, for loans above that amount, they will need to contact CESC, and CESC will send them an application, which is pretty simple and easy to complete. I think there's talks of maybe allowing that application to be available on the website itself, but it's currently not yet available. There's certain approvals that need to be done before that happens. Along with, so for the deferment, I'm sorry, for the hardship accommodation program, there is a first period enrollment of 6 months. And if the borrower is current on all of those payments for that 6 months, the borrower can re-enroll for up to 4 times. And with they have different payment terms. So for the second enrollment, it's again 10% of the monthly payment. And if borrower meets that 6-month period payments, then a third enrollment of 50% of the monthly payment. And then again, provided they meet that criteria for the next 6 months, the fourth and fifth enrollments are 75% of the monthly payment. And this is designed, these larger monthly payments over 6-month terms are designed to kind of gradually expose a borrower to increased payments and to help them make it a habit of repayment, to ultimately allow them to return to the full monthly repayment terms. One thing, it's not on this slide, but I did want to mention was there are options for a borrower experiencing financial distress to maybe kind of catch it early on. SBA, through its resource partners, can help with some low-cost counseling for small businesses. They have partner organizations that can help a borrower review their business plan, identify opportunities to access more capital, provide information on applicable tax benefits, and other counseling services or management services that they can help. They can help you improve how to run your business and give you advice on that. And so you can contact your local district office for that, and they can put you in touch with that. So it's a really great resource that I don't know if a lot of businesses know. So I just wanted to point that out. Next slide, please. Okay, so options for small business in financial distress, other than the hardship accommodation program we discussed. Some of the out-of-court options include dissolution, out-of-court workouts, assignment for benefit of creditors. All of those processes will require that you contact CESC, and they can work through that with you. The other pathway is through court-supervised options, including bankruptcy and receiverships. The bankruptcy part is kind of more frequently. Receiverships are a bit rare. Next slide, please. So how does SBA find out about bankruptcies? There are multiple ways SBA will discover that. Sorry, I'm seeing the mail slot moving. So there's hard copy mail, physical mail to the district offices, to headquarters in Washington, D.C., to the 6 nationwide servicing centers, to PO boxes where payments are sent. We also get electronic notices to the SBA email box, which is directed to headquarters and then redirected out to whichever office handles that will be handling that bankruptcy. We get referrals from the Department of Justice and the U.S. trustees' offices. And sometimes we get contacted directly from debtors' counsel, especially with respect to Chapter 11s, where some sort of first day motion is required and SBA's consent is needed. So those are the ways that we learn about bankruptcy. Next slide. Oh, sorry. Okay, so some of the issues we handle, again, we talked about first day motions in Chapter 11 cases, specifically including cash collateral, working out adequate protection payments, working out lien replacements, agreeing to budget for the use of funds. I just did want to point out also that for payment of insiders, SBA generally allows that only after the debtor makes the proper motion and it's approved by the court. But one of the big questions SBA gets, or one of the questions asked about to SBA is, what does SBA's lien attach to? And again, these are for COVID EIDLs that are greater than $25,000. Basically, the lien attaches to all of debtors' personal property assets. This can include equipment, inventory, accounts and accounts receivable, such as payments from customers, payments from borrowers, for instance, if the borrower makes a loan, to third parties. Insurance payouts is also subject to SBA's lien. Instruments, including promissory notes, general intangibles, including tax refunds and employee retention tax credits, which I think it's kind of petering out a little bit, but those are things that SBA will assert its lien against. There's also certain IP rights like trademarks and copyrights, all of which are included and listed in, or the categories of which are listed in SBA's security agreement and the UCC1 filing. And it also includes proceeds of all of the identified collateral. I did want to point out that while vehicles are listed in SBA's lien, SBA likely won't assert a lien as to the vehicles unless a certificate of title is on file. Another issue that comes up are business valuations, especially when SBA's claim is only partially secured based on the value of the collateral. So borrowers or debtors will want to bifurcate that. Always a good idea to approach the SBA before filing a motion, because oftentimes you can achieve a stipulation for that, which would make it easier for approval by the court. There's also asset sales in Chapter 7s. SBA often will agree to an agreement with the Chapter 7 trustee for a carve out or allowing a surcharge to sell the collateral. I've also had cases in Chapter 7 cases where there is no personal guarantee, but the principals want to buy either the assets or the inventory, the equipment or the inventory for, related to their other businesses. And those are things that we will engage in also. And one of the ways we achieve that is through a stipulation under 11 USC section 725 with the Chapter 7 trustee and or the borrower. It essentially abandons the assets to the SBA to dispose of. Another issue that comes up in Chapter 11 is voting. SBA is often asked to vote for the plan to try to achieve a consensual plan. But SBA, along with other federal agencies, rarely votes in Chapter 11 plans. And that is because there could be interests by sister agencies, usually the IRS, that would prevent it from casting a vote, because that could impair the other agencies' interests, whether or not they're identified specifically, because there could be a lien that's unknown. So in very rare circumstances, will SBA be authorized to vote for a plan. One of the ways that's kind of been resolved is SBA can stipulate to plan treatment of its specific claim. And some courts have accepted the stipulation to help determine that a plan is consensual. One thing I did want to mention at this point is I often ask in meetings of creditors, we often ask about how the debtor used the proceeds. And so the debtor should be prepared to respond to that and to be able to produce documentation, maybe not at the meeting of creditors, but if it's requested after that, showing how the proceeds were used, including spreadsheets, bank statements, and other documents. Like a lot of times debtors generally respond, I used it for working capital, but they need to explain exactly how those proceeds were used. Another important issue that happens is service on SBA. Next slide, please. So proper service on SBA is very important. And proper service means service on SBA and the appropriate U.S. Attorney's office. Sometimes debtors serve one or the other, but they really should serve both. And I don't know if it's widely known, but under Bankruptcy Rule 5003E, the clerk of the court is required to keep a register of mailing address for designated federal, state, and local governmental units as their official mailing address. So here is a screen capture of the Arizona Bankruptcy Court webpage. And if you look under, I can try to circle it, you can see court information, and then there is a registry of state and federal addresses, and then you can see this is the address where you serve the SBA. So it's important that SBA knows about the bankruptcy, so proper service is really necessary, especially if immediate action is needed to work things out. Again, like Chapter 11 cash collateral or collateral sales, things like that. So with that, I will turn it over to Gil.
Thanks, Ann. So I'm keeping an eye on the time, and I want to be respectful of everybody's time, so I'm going to try to just hit the highlights here. So as Ann mentioned, that we ask information about how debtors used the cash, or how they use the money that they received. The reason why is because there's it should come to nobody's surprise that there's been a lot of PPP loan fraud cases. The DOJ investigates those. They have a fraud task force. They have a website. They have a hotline. If you have information, there have been criminal prosecutions. There have been civil actions, and under the False Claims Act or under FIREA. One of the things that comes up in bankruptcy is that we may be either SBA might be seeking an administrative penalty. This comes under 13 CFR 123.9. I just had to remember that. SBA can charge a penalty, administrative penalty of 1.5 times the principal. So a $500,000 loan, we can impose a civil penalty of $750,000 if there has been a misuse of proceeds. So there have been several bankruptcy cases where we have filed both a proof of claim based on the loan and then an unsecured 1.5 times principal administrative penalty, and then we try to collect as much as we can. But that's for misuse of the proceeds. We can and have objected to discharge. We've tried to seek a 523 action for somebody misusing the proceeds, lying, or breach of fiduciary duty. That's an interesting one under, I think it's A7, where it's the principal of the company then takes money and does something that they shouldn't do with it. And we have our very large fair share of criminal referrals through our Office of Inspector General, the OIG. Here are a couple of examples of ways that cases have gone. We had a corporate borrower where the principal, he took the money, he transferred the money to himself. It was a Chapter 7 case. This was one in the 341A. I asked, what did you do with the money? Where then he said, I used it for the business. Great. Show me where you used it for the business. Show me the documents. And we found out that the money was actually moved to himself. The U.S. trustee filed a motion to dismiss or convert. In this chapter, the Chapter 11 got converted to 7, and the trustee filed a fraudulent transfer action against the principal, got a judgment, and the guy is paying in bits and pieces in Chapter 7. In another case, we had a principal that applied for an EIDL for a business that had already closed. That should be a red flag there, and instead used the money for personal living expenses, then filed a personal bankruptcy. Said, what did you do with that money? And we ended up getting a non-dischargeable action and violations under the False Claims Act. We had another case in LA. This was multiple corporate borrowers. They received both EIDL and PPP funds. And this was one guy who owned lots of different businesses, and the money ended up being moved around. The judge sua sponte appointed a Chapter 11 trustee who later moved for substantive consolidation and pulled in the non-debtor companies, the recipients of some of that EIDL and PPP cash. And they all got substantively consolidated and then therefore got pulled into the bankruptcy case. And those were assets that were then paid to creditors. And there we also filed the administrative penalties. There was a loan by a corporation, and it was personally guaranteed by the principal. So a loan to the business. The individual was the guarantor who filed for bankruptcy. As part of his bankruptcy, he tried to discharge that guarantee to SBA. It was revealed that the principal had transferred the EIDL funds to himself and for himself. And he ended up stipulating with SBA to a non-dischargeable judgment. This is a hat tip to the U.S. Trustee's Office because they are the ones who actually combed through the documents. And they asked him, why is there an investment fund? But why is there? I think it was a Robinhood account, in that money from the business went to the Robinhood account. And then the Robinhood account was in the name of the individual. So a hat tip to our partners at the U.S. Trustee's Office, who combed through these documents and raised these red flags. And then I'll end here with an Arizona case, and again another hat tip to the U.S. trustees, to Jennifer. In a Chapter 11 case, while the case was going, while in Chapter 11, they looked at the MORs and they saw cash. Where did this cash come from? while you are in Chapter 11, it says, oh, we got both EIDL and PPPs. Well, you can't get an EIDL and PPPs while the company is in bankruptcy. And it turns out that they had lied in their forms to SBA in order to qualify. The U.S. trustee discovered that, filed a motion to convert or dismiss, and we filed administrative penalties in there too. So these are sort of some examples of ways where cases have ended less well, but just wanted to show you that these issues do and are coming up. Wanted to leave some time here for questions. I was hoping to have a few more minutes than we do, but we want to make ourselves available, and to the extent that you want to shoot us any emails directly or through the organization, we're happy to answer.
Thank you, Gil. And for the rest of you, you're welcome to unmute yourself and ask any questions that you have. Oh, I see one question just popped in the chat. I was going to say no one put questions in during. Are you able to read that, Gil?
If a corporation has a COVID EIDL personally guaranteed by its owner, and the owner files a Chapter 13 case, does a guarantor's bankruptcy accelerate their loan? No. The corporation can continue to make the regular monthly payments. The answer to that is no. This popped to mind. We've had some Chapter 7 cases where it's in the business is in the name of an LLC, 100% single member owned LLC, and then the individual files for bankruptcy. The trustee has then tried to step into the shoes of the 100% owner LLC and try to pull in business assets. That's one where we do get involved, because we say that we have a loan on the business assets, and now they're being sort of pulled into the bankruptcy case through that sort of LLC arrangement. So we've dealt with Chapter 7 trustees there that way, but the answer to the 13 is no, it does not accelerate. Would we sign off on an order confirming the plan? This is where it gets really weird, and there are different courts that interpret what does it mean to be consensual. A sub 5 to be consensual, meaning do we not object, or do we have to vote yes? And there are different cases. I mean, we're happy to work with you on it. In RJ, I have worked with you on some of these kinds of cases, but there's sort of different positions on it. And there's one judge in LA that has he agreed that by not objecting in time, SBA waived its right to object by the objection deadline, and therefore, by having waived our objection, he deemed it sort of consent. So there's it sort of depends. And will we always file a proof of claim in a guarantor's Chapter 13 in which it has notice? I'd say for the most part, yes. Again, this is one where as long as the Chapter 13, as long as the debtor has actually guaranteed and it's above that threshold, because we have many cases where it might be a $100,000 loan, so there's no personal guarantee, and they will notice SBA, and we're like, well, what do we do? You've noticed us, but we don't really want to, there's personal guarantee in the case. So you're just sort of noticing us to let us know. Thank you very much, but no, we don't file it. But otherwise, as close to always as we can. And we've done it that way as a contingent claim. It's a guarantee as contingent.
I was just going to mention that, because I think part of the concern with that is when there's a personal guarantee, that means the SBA loan is above 500,000, right? And
200.
Or is it 250? Oh, is it 200? Okay. So the concern, I think, from the consumer bankruptcy attorney side is the unsecured debt cap, I believe, is 465,000. But I think there is a good argument, and it just came out of Gil's mouth before mine, that is a contingent debt. So long as the obligor debtor is still operating and is still able to continue making its own payments, I think there's a good argument that perhaps that debt doesn't get counted for 109E debt cap purposes.
And I filed it as contingent, and then comes a motion to value the claim at 0, or they'll say, we're about to do it. Will you withdraw, or will you do something? But yeah, the general answer is yes. We try to file a claim to preserve our right for recovery.
And I think practice tip on our end is that we should make sure we're listing those SBA debts for our individual guarantor debtors as contingent, so long as that company is still operating and is still making its own loan payments, to try to hedge that 109E battle off. I see it is 102. I have placed the CLE certificate in the chat for you. Please grab it from there. Again, this is the only place and time you're going to find that certificate. So grab it, download that PDF, make sure the .pdf stays with it, or add it if you need to so that it will open with your Adobe or whatever you use for that. We are recording, thank you, Diane. We are recording this, as we've said, and the recording will be placed on a YouTube channel and also available on the ACBC website. You're welcome to stick around a little longer if our presenters are willing to stick around and answer any more questions. I came up with one, so I'll toss it to you, but I just want to make a call again. If anyone has a question and wants to speak up before me, yes, Lisa, go for it. Anybody
I
else
want to
too?
follow up.
Mhm.
So sorry to cut you off.
No,
What you were talking about, Gil. So you've got the Chapter 13 debtor. They're still operating their business. The business is going to continue to pay, so long as nothing untoward happens. Does that debt against the guarantor get discharged if they could complete their Chapter 13 plan?
Yes, then the guarantee gets discharged.
So then it would just be the collateral that the business has, and
Correct.
hopefully the business continues on.
Correct.
that's
Crystal,
great
I'll let you go,
information.
but I have another question as well.
No, go ahead. Go ahead.
Okay, so, and I know that you guys can't do anything about this, but I thought I'd ask anyway. So I have clients that have had their loans discharged through a Chapter 13, or we've worked it out, and the business has been dissolved, and they still get notices from the SBA. Any tips or tricks as to how to get that stopped? Because every month I know when those notices go out, because every month, no matter what I have said to my clients, I get I got this in the mail and it says immediate, response required. And I'm like, you're going to get that forever. And just find a little place, like look at Sex in the City where she put all of her stuff in one little folder. That's where you need to put it. Do you have any ideas, or am I correct that it's just going to happen forever?
So the mail, and Anne may have seen some of these too. The mail doesn't, it comes, but it doesn't really say how it's, or sort of to whom it's addressed. So sometimes it's being addressed, it might be addressed to you, Lisa, as the guarantor. And sometimes it might be addressed to you, Lisa, as the principal of the business. And so just because the individual may have filed for bankruptcy and have that discharge, it might still be coming to you addressed, and it doesn't say that, but it's coming to you
For the
as
business.
the business, but care of,
Right. And I was not indicating that you guys are violating the stay, because my client, she personally is fine. Her business dissolved, which you may not know about, even though I sent a letter that said we've dissolved, and it comes to her as the president of the business, that SBA still, it either hasn't trickled down, but is there a way to stop that? Because the business didn't file bankruptcy, and I don't think anything is necessarily wrong. I think overwhelmed is more the term.
Yeah, and it could be that it hasn't trickled down. I send some correspondence to the CESE servicing email.
I still like my idea of just having a separate file, and just because it's just going to happen, because the
But
business
you have to have the appropriately sized shoe closet.
right. Well, and it's coming by email, so it's not even killing trees, okay, go ahead, Crystal.
Yeah. So early in your presentation, Gil, you mentioned, and it was on your slide, that loans can't be made to businesses investing in real estate for rental. And I immediately thought of Airbnb businesses, and I assume that qualifies. So the SBA won't lend to an operator of Airbnb under that rule. Is that right?
That's an interesting twist. I don't recall. I mean, there's a whole SOPs as to who we do and we don't. And one of that came up in the very early days of the pandemic, because SBA does not lend to businesses in bankruptcy. But that provision is not in the CARES Act, which Congress passed. And so there was, in the very early days after the CARES Act, there were businesses in bankruptcy where there was this little cottage industry of various cases filed saying, yes, I want, court, under 363, allow me to go 364, allow me to go get post-petition financing. And SBA was saying, no, you can't. And they were asking for injunctions. And they were saying whether the fact that SBA was not allowing a business in bankruptcy to qualify, whether that was discrimination under 525, or whether, and these were provisions that SBA was imposing upon, and whether that was okay. And anyway, it all got cleared up, but we had different courts, even within Arizona, we had different judges saying yes or no, depending on different things. So until that got straightened out, courts. But we have a whole list of provisions of things that do and do not qualify. But I would imagine that if it's simply for what would be called passive income, then it would not qualify. The idea is that this is for employing people and generating jobs and contributing to the economy. And you can't borrow in order to invest, and it would be that type of. So I think the answer is no.
Okay, so that was more than, it sounds like, more focused on the acquisition loan. Like I can't get an SBA loan to acquire a rental property.
Right.
But perhaps running an Airbnb business would qualify. Interesting. Okay. You referred to, and again, the rest of you are welcome to unmute if you have any questions and speak up. I have one more. You referred to administrative penalties. The SBA will seek administrative penalties.
Yes.
Is that an administrative expense claim entitled to priority under the bankruptcy code? Is that what we're talking about?
It would be. It's just an unsecured. Okay. It's just an unsecured claim.
So it's the 1.5.
It's a large one, but it would be just an unsecured claim.
So that relates to the 1.5 penalty that you were talking about just before that. Gotcha. Okay.
Correct.
Questions from the audience? Yeah.
How many of the, do you happen to know, like, because the EIDLs are pretty new in the scheme of things, how aggressive has enforcement been, aside from the repeated emails that say immediate response requested? Has there, if people haven't, so they're not filing bankruptcy, they're just not paying for whatever reason, like,
no, I can tell you that they have been there have been a lot of referrals through our Office of Inspector General, or OIG, and different jurisdictions just have certain backlogs or priorities. I know that PPPs were higher dollar than the COVID EIDLs. For a long time were capped at 150, and from 150 they moved up to 500, and from 500 to $1 million. And so there are a lot of smaller dollar loans, and I think they're just sort of prioritizing the bigger dollar loans.
For sure.
They have been criminal referrals on all of them.
It's just like a client. Oh, sorry, Anne, go ahead.
Yeah, sorry. Aside from that, I just did want to mention that they've also been charged off and referred to Treasury for collection, even if so this is pre-bankruptcy. So they are enforcing against delinquent loans.
So like SBA can charge it off, but then they turn it over to Treasury to collect whatever they can get from it.
And that can be through administrative wage garnishments, that could be garnishing tax returns, that can be
ERC money,
like the Social Security, Medicare kind of thing. They could be nipping at
anything that's coming, any federal benefits.
Correct.
And what is it, like a certain, like student loans are 270 days and you're delinquent? Is there a certain time frame that you guys?
I think it's 180. I think it's 180 days.
So you don't make payments for 180 days. You're looking at potentially getting referred to the Department of Treasury.
Correct.
And then you're going to start collections, or at some point it might get charged off from SBA. Or is it when it gets to Treasury, it's like SBA is done with it?
SBA is done. We actually have a little red flag on top saying, when you pull up the loan, it'll say referred to Treasury. Like we've lost the ability to do anything, and therefore, if any payment plans, anything, then it has to be done through Treasury. If there is a bankruptcy, then Treasury will kick it back to us, and then we will then file the claim and whatever. But until then, all the servicing, OICs, negotiations, payments, everything is done through Treasury, and Treasury adds on fees and penalties and stuff like that.
And so you just contact Treasury if you need to work out something for your
Yes,
client?
there'll be a phone number there, or if you ever need it, it's Treasury cross servicing is what they call it, or the Treasury offset program. But there's a toll-free number. And if you ever need help, let me know.
Great.
Well, does anybody else have any questions?
I have one more question.
Sure.
I heard our president say the other day that when he was talking about the hurricane disaster, that the funding for SBA is running low, contrary to the FEMA funding running low. And I was wondering, what does that mean? Is that just funding for new loans? So if Congress doesn't get its stuff together quickly, will the SBA be unable to offer new loans? Is that the ramification, or is it broader than that?
I think that's a little bit above my pay grade, but I will tell you that disaster funding is a separate budget. It's a separate line item. It's a separate staff. They actually have I'm trying to think of the right word, the appropriations. So the appropriations for disaster is different, and it's a separate item from appropriations for SBA generally, and we get paid and expenses out of different funds. But I think the latest that I heard was that they were just, in terms of money going out, they can approve a loan, but then the loan will be sitting there pending new money coming in before the money goes out.
Yeah. Thank you. Any other questions before we let everyone go off of our Zoom? Thanks for sticking around, most of you, and thank you too for sticking around to answer as many questions as you could. We sure do appreciate your time today, not only today, but also preparing for this. I know that's never a short period of time, so we're very grateful to both of you.
Yeah, shockingly, everyone's been quiet except for me and Crystal.
Nothing else. We're happy to, enjoy the long holiday weekend.
So I just want to say thank you guys so much. It's been really great working with you and getting to know you. And I'm less scared of the SBA because you guys have nice faces and you're willing to share your information. So thank you all for coming. Thank you, Ann and Gil. Crystal, do you have any other final? You guys are getting like tons. We won't shut it down while you're getting kudos in the chat.
I was going to say, thank you so much. It's really good information and really nice to actually put some faces to the names that I have seen on emails back and forth. So
yes,
I'm going to take off now. Thank
you.
you.
Bye. Let me just do
within the slides, there was that sort of chart that we made, and some of it is, it's just sort of a handy reference, you can sort of pin it up.
Yeah, I can't tell you the number of times that we like all of those questions on the listserv. So now we can just like cut and paste and be like, we got it from SBA. Here you go.
And we included in there these, I just call them sort of tombstones as to sort of, some of these PPP like was only from 2020 to whatever. So if you're going through your client's stuff and they have a loan from 1990 or 2019, if it's 2019. It's not a PPP. It's not an EIDL. It'll be right, just because those loans didn't exist then. And if it's a loan from 2024, it's not either, because those loans no longer existed. But just those types of years might help in sort of whittling down what it is that you're asking your clients to provide.
Well, my clients always know exactly how much they owe and what kind of loan it is. Like they're on it.
Where do you find them?
I'm never wondering.
Will you send some of those my way, please?
That was heavy sarcasm, people. Like the big sarcasm. Like I would be shocked if someone said, so this is great information so that we can decipher what's going on and get them in the right place. So
good. Real quick before everyone leaves, including to our new two speakers, I just put a flyer in the chat for ACBC's Fall Social, which will take place on November 7th. It is here in Phoenix. For those of you who are not in Phoenix, it'll be at Enchiladas, again, Thursday, November 7th. It is, you're all welcome to join us. And then for ACBC members, encourage you to always join our Thursday think tanks at 4 p.m. on Zoom. And also every third Wednesday of the month, we have an open happy hour. We try not to talk too much business think tank stuff. So thank you again to our speakers. We hope to see some of your faces at our Fall Social. Again, grab that flyer before we disconnect from here. It's also on the ACBC website, though. Thank you, guys.
Bye.
Thank you.
Thank you so much. I appreciate it.
Crystal.